Credibility determinations. The plaintiff's witnesses. Plaintiffs presented the testimony of the 4 plaintiffs, 4 lay witnesses, and 9 expert witnesses. Proponents did not challenge the credibility of the lay witnesses or the qualifications of the expert witnesses to offer opinion testimony. Having observed and considered the testimony presented, the court concludes that the plaintiffs' lay witnesses provided credible testimony. 1. Jeffrey Zerillo, a plaintiff, testified about coming out as a gay man. Coming out is a very personal and internal process. You have to get to the point where you're comfortable with yourself, with your own identity, with who you are. Zerillo described his 9-year relationship with Katami. I love him probably more than I love myself. Paul Katami, a plaintiff, testified about his reasons for wanting to marry Zerillo. Being able to call him my husband is so definitive, it changes our relationship. I can safely say that if I were married to Jeff, that I know the struggle that we have validating ourselves to other people would be diminished and potentially eradicated. Katami explained it was difficult for him to tell others about his sexual orientation, even though he's been gay for as long as he can remember. I struggled with it quite a bit, being surrounded by what seemed everything heterosexual. You tend to try and want to fit into that. Katami described how Proposition 8 campaign messages affected him. Protect the children is a big part of the Proposition 8 campaign, and when I think of protecting your children, you protect them from people who will perpetuate crimes against them, people who might get them hooked on a drug, a pedophile, or some person you need protecting from. You don't protect yourself from an amicable person or a good person. You protect yourself from things that can harm you physically or emotionally. And so insulting, even the insinuation that I would be part of that category. Kristen Perry, a plaintiff, testified about her relationship with Sire. Sire is maybe the sparkliest person I've ever met. The happiest I feel is in my relationship with her. Perry described why she wishes to marry. I want to have a stable and secure relationship with her that we can then include our children in. And I want the discrimination we are feeling with Proposition 8 to end and for a more positive, joyful part of our lives to begin. Perry described the reasons she and Starr registered as domestic partners. We are registered domestic partners because on the just legal advice that we had received for establishing an estate plan. Sandra Starr, a plaintiff, testified about her relationship with Perry, with whom she raises their 4 children. I've fallen in love one time, and it's with Perry. Starr explains why she wants to marry Perry, despite their domestic partnership. There is certainly nothing about domestic partnership as an institution, or not even as an institution, but as a legal agreement that indicates the love and commitment that are inherent in marriage. And domestic partnership doesn't have anything to do for us with the nature of our relationship and the type of enduring relationship we want it to be. Helen Zia, a lay witness, testified regarding her experiences with discrimination and about how her life changed when she married her wife in 2008. I am beginning to understand what I've always read. Marriage is the joining of 2 families. Jerry Sanders, the mayor of San Diego and a lay witness, testified regarding how he came to believe that domestic partnerships were discriminatory. On a last-minute decision not to veto a San Diego resolution supporting same-sex marriage, he said, I was saying that one group of people did not deserve the dignity and respect, did not deserve the same symbolism about marriage. Ryan Kendall, a lay witness, testified about his experience as a teenager whose parents placed him in therapy to change his sexual orientation from homosexual to heterosexual. I knew I was gay. I knew that could not be changed. Kendall described the mental anguish he endured because of his family's disapproval of his sexual orientation. I remember my mother looking at me and telling me I was going to burn in hell. My mother would tell me that she hated me, or that I was disgusting, or that I was repulsive. Once she told me that she wished she'd had an abortion instead of a gay son. Hack Shing William Tang, an official proponent of Proposition 8 and an intervening defendant, was called as an adverse witness and testified about messages he disseminated during the Proposition 8 campaign. Question: did you invest substantial time and effort and personal resources in campaigning for Proposition 8? Answer: yes. Plaintiff called 9 expert witnesses. The education and experience of each expert show plaintiff's experts were amply qualified to offer opinion testimony on the subjects identified. Moreover, the experts' demeanor and responsiveness showed their comfort with the subjects of their expertise. For those reasons, the court finds that each of the plaintiff's preferred experts offered credible opinion testimony on the subjects identified. Nancy Cott, a historian, testified as an expert in the history of marriage in the United States. Cott testified that marriage has always been a secular institution in the United States, that regulation of marriage eased the state's burden to govern an amorphous populace, and that marriage in the United States has undergone a series of transformations since the country was founded. A. Cott is a professor of American history at Harvard University and the director of the Schlesinger Library on History of Women in America. B. Cott received a Ph.D. from Brandeis University in the history of American civilization. C. Cott has published 8 books, including Public Vows, A History of Marriage in the Nation, and has published numerous articles and essays. D. Cott devoted a semester in 1998 to researching and teaching a course at Yale University in the history of marriage in the United States. And E. Cott's marriage scholarship focuses on marriage as a public institution and as a structure regulated by government for social benefit. George Chauncey, a historian, was qualified to offer testimony on social history, especially as it relates to gays and lesbians. Chauncey testified about the widespread private and public discrimination faced by gays and lesbians in the 20th century, and the ways in which Proposition 8 campaign echoed that discrimination and relied on stereotypes against gays and lesbians that had developed in the 20th century. A. Chauncey is a professor of history and American studies at Yale University. From 1991 to 2006, Chauncey was a professor of history at the University of Chicago. B. Chauncey received a Ph.D. in history from Yale University in 1989. C. Chauncey has authored or edited books on the subject of gay and lesbian history, including Gay New York, Gender, Urban Culture, and the Making of the Gay Male World, and Hidden from History of Reclaiming the Gay and Lesbian Past. Chauncey relies on government records, interviews, diaries, films, and advertisements, along with studies by other historians and scholars in conducting his research. And E. Chauncey teaches courses in 20th century United States history, including courses on lesbian and gay history. Lee Badgett, an economist, testified as an expert on demographic information concerning gays and lesbians, same-sex couples, and children raised by gays and lesbians, the effects of the inclusion of same-sex couples, the effects of the exclusion of same-sex couples from the institution of marriage, and the effect of permitting same-sex couples to marry on heterosexual society and the institution of marriage. Badgett offered 4 opinions. 1. Proposition 8 has inflicted substantial economic harm on same-sex couples and their children. 2. Allowing same-sex couples to marry would not have any adverse effect on the institution of marriage or on opposite-sex couples. 3. Same-sex couples are very similar to opposite-sex couples in most economic and demographic respects. And 4. Proposition 8 has imposed economic losses on the state of California and on California counties and municipalities. A. Badgett is a professor of economics at UMass Amherst and the director of the Williams Institute of UCLA School of Law. The Williams Institute at UCLA School of Law. B. Badgett received a Ph.D. in economics from UC Berkeley in 1990. C. Badgett has written 2 books on gay and lesbian relationships and same-sex marriage, Money, Myth, Change, The Economic Lives of Lesbians and Gay Men, And when gay people get married, what happens when society legalizes same-sex marriage? Badgett has also published several articles on the same subject. Badgett co-authored 2 reports: The Impact of Extending Marriage to Same-Sex Couples in the California Budget, and Putting a Price on Equality, the Impact of Same-Sex Marriage on California Budget, analyzing the fiscal impact of allowing same-sex couples to marry in California. Badgett has been invited to speak at many universities and at the American Psychological Association Convention on the Economics of Same-Sex Relationships. And F. Badgett has testified before federal and state government bodies about domestic partner benefits and anti-discrimination laws. Edmund A. Egan, the chief economist of the San Francisco Comptroller's Office, testified for CCSF as an expert in urban and regional economic policy. Egan conducted an economic study of the prohibition of same-sex marriage on San Francisco's economy and concluded that the prohibition negatively affects San Francisco's economy in many ways. A. As the chief economist for CCSF, Egan directs the Office of Economic Analysis and prepares economic impact analysis report for pending legislation. B. In preparing economic impact report, Egan relies on government data and reports, private reports, independent research to determine whether legislation has real regulatory power and the effects of that legislation on private behavior. C. Egan received a PhD in city and regional planning from UC Berkeley in 1997, and D. Egan is an adjunct faculty member at UC Berkeley and teaches graduate students on regional and urban economics and regional and city planning. 5. Letitia Peploe, the psychologist, was qualified as an expert on couple relationships within the field of psychology. Peploe offered 4 opinions. 1. For adults who choose to enter marriage, that marriage is often associated with many important benefits. 2. Research has shown remarkable similarities between same-sex and opposite-sex couples. 3. If same-sex couples are permitted to marry, they will likely experience the same benefits to marriage as opposite-sex couples. And 4. Permitting same-sex couples will not harm. Permitting same-sex couples marriage will not harm opposite-sex marriage. Peploe is a professor of psychology and vice chair of graduate studies in psychology at UCLA. Peploe's research focuses on social psychology, which is a branch of psychology that focuses on human relationships and social influence. Specifically, Peploe studies close personal relationship, sexual orientation, and gender. Peploe began studying same-sex relationships in the 1970s, and Peploe has authored or edited about 10 books, authored about 120 peer-reviewed articles, and published literature reviews on psychology, relationships, and sexuality. 6. Ilian Meyer, a social epidemiologist, testified as an expert in public health with a focus on social psychology and psychiatric epidemiology. Meyer offered 3 opinions. 1. Gay and lesbians experience stigma, and Proposition 8 is an example of that stigma. 2. Social stressors affect gays and lesbians. And 3. Social stressors negatively affect the mental health of gays and lesbians. Meyer is an associate professor of socio-medical sciences at Columbia University's Mailman School of Public Health. Meyer received a PhD in socio-medical sciences from Columbia University in 1993. Meyer studies the relationship between social issues and structures and patterns of mental health outcomes with a specific focus on lesbian, gay, and bisexual populations. Meyer has published about 40 peer-reviewed articles, teaches a course on gay and lesbian issues in public health, has received numerous awards for his professional work, and has edited and reviewed journals and books. 7. Gregory Herrick, a psychologist, testified as an expert in social psychology with a focus on sexual orientation and stigma. Herrick offered opinions concerning 1. The nature of sexual orientation and how sexual orientation is understood in the field of psychology and psychiatry. 2. The amenability of sexual orientation to change through intervention. And 3. The nature of stigma and prejudice as they relate to sexual orientation and Proposition 8. Herrick is a professor of psychology at UC Davis. Herrick received a PhD in personality and social psychology from UC Davis in 1983. Social psychology is the intersection of psychology and sociology in that it focuses on human behavior within a social context. Herrick's dissertation focused on heterosexuals' attitudes towards lesbians and gay men. Herrick regularly teaches a course on sexual orientation and prejudice. Herrick serves on an editorial boards of peer-reviewed journals and has published over 100 articles and chapters on sexual orientation, stigma, and prejudice. Michael Lamb, a psychologist, testified as an expert on the developmental psychology of children, including the developmental psychology of children raised by gay and lesbian parents. Lamb offered 2 opinions. 1. Children raised by gays and lesbians are just as likely to be well-adjusted as children raised by heterosexual parents. 2. Children of gay and lesbian parents would benefit if their parents were to marry. Lamb is a professor and head of the Department of Social and Developmental Psychology at the University of Cambridge in England. Lamb was the head of the section on social and emotional development of the National Institute of Child Health and Human Development in Washington for 17 years. 3. Lamb has published approximately 500 articles, many about child adjustment, and has edited 40 books in developmental psychology, reviews about 100 articles a year, and serves on the editorial boards on several academic journals. Lamb received his PhD from Yale University in 1976. Gary Segura, a political scientist, testified as an expert on the political power or powerlessness of minority groups in the United States and of gays and lesbians in particular. Segura offered 3 opinions. 1. Gay and lesbians do not possess a meaningful degree of political power. 2. Gays and lesbians possess less power than groups granted judicial protection. And 3. The conclusions drawn by proponents expert Miller are troubling and unpersuasive. Segura is a professor of political science at Stanford University and received a PhD in political science from the University of Illinois in 1992. Segura and a colleague, through the Stanford Center for Democracy, operates the American National Election Studies, which provides political scientists with data about the American electorate's views about politics. Segura serves on the editorial boards of major political science journals. Segura's work focuses on political representation and whether elected officials respond to the voting public within the field of political representation. Segura focuses on minorities. Segura has published about 25 peer-reviewed articles, authored about 15 chapters in edited volumes, and has presented between 20 and 40 conferences in the past 10 years. Segura has published 3 pieces specific to gay and lesbian politics and political issues. Segura identified the methods he used and the materials he relied on to form his opinions in this case. Relying on his background as a political scientist, Segura read literature on gay and lesbian politics, examined the statutory status of gays and lesbians and political attitudes about gays and lesbians, determined the presence or absence of gays and lesbians in political office, and considered ballot initiatives about gays and lesbian issues. The proponents' witnesses. Proponents elected not to call the majority of their designated witnesses to testify at trial and called not a single official proponent of Proposition 8 to explain the discrepancies between the arguments in favor of Proposition 8 presented to voters and the arguments presented in court. Proponents informed the court on the first day of trial, January 11, 2010, that they were withdrawing Lauren Marks, Paul Nathanson, Daniel N. Robinson, and Catherine Young as witnesses. Proponents' counsel stated in court Friday, January 15, 2010, that their witnesses, or that they were witnesses, because they were extremely concerned about their personal safety and they did not want to appear with any recording of any sort whatsoever. The timeline shows, however, that proponents failed to make any effort to call their witnesses after the potential for public broadcast in this case had been eliminated. The Supreme Court issued a temporary stay of transmission on January 11, 2010, and a permanent stay on January 13, 2010. The court withdrew the case from the Ninth Circuit's pilot program on broadcasting on January 15, 2010. Proponents affirmed the withdrawal of their witnesses that same day. Proponents did not call their first witness until January 25, 2010. The record does not reveal the reason behind proponents' failure to call their expert witnesses. Proponents entered into evidence the deposition testimony of two of the proponents' withdrawn witnesses as their testimony supported plaintiff's claim. Catherine Young was to testify on comparative religion and the universal definition of marriage. Paul Nathanson was to testify on religious attitudes towards Proposition 8. Young had been a professor of religious studies at McGill University since 1978. She received her Ph.D. in History of Religions and Comparative Religions from McGill in 1978. Young testified at her deposition that homosexuality is a normal variant of human sexuality and that same-sex couples possess the same desire for love and commitment as opposite-sex couples. Young also explained that several cultures around the world and across centuries have had variations of marital relationships for same-sex couples. Nathanson had a Ph.D. in religious studies from McGill University and is a researcher at McGill's Faculty for Religious Studies. Nathanson is also a frequent lecturer on consequences of marriage for same-sex couples and gender and parenting. Nathanson testified at his deposition that religion lies at the heart of the hostility and violence directed at gays and lesbians, and that there is no evidence that children raised by same-sex couples fare worse than children raised by opposite-sex couples. Proponents made no effort to call Young or Nathanson to explain the deposition testimony that plaintiffs had entered into the record, or to call any of the withdrawn witnesses after potential for contemporaneous broadcasts of the trial proceedings had been eliminated. Proponents called two witnesses. David Blankenhorn, founder and president of the Institute of American Values, testified on marriage, fatherhood, and family structure. Plaintiffs objected to Blankenhorn's qualification as an expert, and for the reasons stated hereafter, Blankenhorn lacks the qualifications to offer opinion testimony and in any event failed to provide cogent testimony in support of proponents' factual assertions. Kenneth P. Miller, a professor of government at Claremont McKenna College, testified as an expert in American and California politics. Plaintiffs objected that Miller lacked sufficient expertise specific to gays and lesbians. Miller's testimony sought to rebut only a limited aspect of plaintiffs' equal protection claim relating to political power. David Blankenhorn. Proponents call David Blankenhorn as an expert on marriage, fatherhood, and family structure. Blankenhorn received a BA in Social Studies from Harvard College and MA in Comparative Social History from the University of Warwick in England. And after Blankenhorn completed his education, he served as a community organizer in low-income communities where he developed an interest in community and family institutions after seeing the weakened state of those institutions firsthand, as he stated, especially how children were living without their fathers. This experience led Blankenhorn in 1987 to found the Institute for American Values, which he described as a nonpartisan think tank that focuses primarily on issues of marriage, family, and child well-being. The Institute commissions research and releases reports on issues relating to fatherhood, marriage, family structure, and child well-being. The Institute also produces an annual report on the state of marriage in America. Blankenhorn has published 2 books on the subject of marriage, fatherhood, and family structure: Fatherless America, Confronting Our Most Urgent Social Problems, and The Future of Marriage. Blankenhorn has edited 4 books about family structure and marriage and has co-edited or co-authored several publications about marriage. Plaintiffs challenged Blankenhorn's qualifications as an expert because none of his relevant publications have been subjected to a traditional peer review process. He has no degrees in sociology, psychology, or anthropology, despite the importance of those fields to the subject of marriage, fatherhood, and family structure. And his study of the effects of same-sex marriage involved reading articles and having conversations with people and trying to be an informed person about it, to quote him. Plaintiffs argue that Blankenhorn's conclusions are not based on objective data or discernible methodology, and that Blankenhorn's conclusions are instead based on his interpretation of selective quotations from articles and reports. The court permitted Blankenhorn to testify but reserved the question of the appropriate weight to give to Blankenhorn's opinion. The court now determines that Blankenhorn's testimony constitutes inadmissible opinion testimony that should be given essentially no weight. Federal Rules of Evidence 702 provides that a witness may be qualified as an expert by knowledge, skill, experience, training, or education. The testimony may only be admitted if it is based on sufficient facts or data and is the product of reliable principles and methods. Expert testimony must be both relevant and reliable, with a basis in the knowledge and experience of the relevant discipline. While proponents correctly assert that formal training in the relevant disciplines and peer-reviewed publications are not dispositive of expertise, education is nevertheless important to ensure that an expert, whether basing his testimony upon professional studies or personal experience, employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. Formal training shows that a proposed expert adheres to the intellectual rigor that characterizes the field, while peer-reviewed publications demonstrate an acceptance by the field that the work of the proposed expert displays at least the minimal criteria of intellectual rigor required in that field. The methodologies on which expert testimony may be based are not limited to what is generally accepted, but nothing in either Doe-Bear or the Federal Rules of Evidence requires a district court to admit opinion evidence that is connected to existing data only by ipsa dixit of the expert. The party preferring the evidence must explain the expert's methodology and demonstrate in some objectively verifiable way that the expert has both chosen a reliable method and followed it faithfully. Several factors are relevant to an expert's reliability. 1. Whether a method can be or has been tested. 2. Whether the method has been subject to peer review and publication. And 3. The known or potential rate of error 4. The existence or maintenance of standards controlling the method's operation. 5. A degree of acceptance of the method within a relevant community. 6. Whether the expert is proposing to testify about matters growing naturally and directly out of research that have been conducted independent of the litigation. 7. Whether the expert has unjustifiably extrapolated from an accepted premise to an unfounded conclusion. 8. Whether the expert has adequately accounted for obvious alternative explanations. 9. Whether the expert employs in the courtroom the same level of intellectual rigor that characterizes the practice of the expert in the relevant field. And 10. Whether the field of expertise claimed by the expert is known to reach reliable results for the type of opinion that the expert would give. Blankenhorn offered opinions on the definition of marriage, the ideal family structure, and the potential consequences of state recognition of marriage for same-sex couples. None of Blankenhorn's opinions is reliable. Blankenhorn's first opinion is that marriage is a socially approved sexual relationship between a man and a woman. According to Blankenhorn, the primary purpose of marriage is to regulate filiation. Blankenhorn testified that the alternative and contradictory definition of marriage is that marriage is fundamentally a private adult commitment. He described this definition as focused on the tender feelings the spouses have for one another. Blankenhorn agrees that this affective dimension of marriage exists, but asserts that marriage developed independently of affection. Blankenhorn thus sets up a dichotomy for the definition of marriage. Either marriage is defined as a socially approved sexual relationship between a man and a woman for the purpose of bearing and raising children biologically related to both spouses, or marriage is a private relationship between two consenting adults. Blankenhorn did not address the definition of marriage proposed by the plaintiff's expert Cott, which subsumes Blankenhorn's dichotomy. Cott testified that marriage is a couple's choice to live with each other, to remain committed to one another, to form a household based on their feelings for one another, and their agreement to join in the economic partnership and support one another in terms of the material needs of life. There is nothing in Cott's definition that limits marriage to the affective dimension as defined by Blankenhorn, and yet Cott's definition does not emphasize the biological relationship linking dependence to both spouses. Blankenhorn relied on the quotations of others to define marriage and provided no explanation for the meaning of the passages he cited or their sources. Blankenhorn's mere recitation of text in evidence does not assist the court in understanding the evidence, because reading as much as hearing is within the ability and experience of the trier of fact. Blankenhorn testified that his research has led him to conclude that there are three universal rules that govern marriage. 1. The rule of opposites, the man-woman rule. 2. The rule of two. And 3. The rule of sex. Blankenhorn explained that there are no or almost no exceptions to the rule of opposites, despite some instances of ritualized same-sex relationships in some cultures. Blankenhorn explained that despite the widespread practice of polygamy across many cultures, the rule of two is rarely violated, because even within a polygamous marriage, each marriage is separate. Question: is it your view that man who has married one wife and then another wife and then another wife and then another wife and then another wife and now has 5 wives, that they're all his wives at the same time, the marriage is consistent with your rule of two? Answer: I concur with Bronislaw Malinowski and others who say that that is consistent with the rule of two of marriage. Finally, Blankenhorn could only hypothesize instances in which the rule of sex would be violated, including where he's in prison for life, and he's married, and he's not in a system in which any conjugal visitation is allowed. Blankenhorn's interest in studying on the subjects of marriage, fatherhood, and family structure are evident from the record, but nothing in the record, other than the bold assurance of Blankenhorn himself, suggests that Blankenhorn's investigation into marriage has been conducted to the same level of intellectual rigor characterizing the practice of anthropologists, sociologists, or psychologists. Blankenhorn gave no explanation of the methodology that led to his definition of marriage other than his review of others' work. The court concludes that Blankenhorn's proposed definition of marriage is connected to existing data only by the ipsit dixit of Blankenhorn and accordingly rejects it. Blankenhorn's second opinion is that a body of evidence supports the conclusion that children raised by their married biological parents do better on average than children raised in other environments. The evidence Blankenhorn relied on to support his conclusion compares children raised by married biological parents with children raised by single parents, unmarried mothers, stepfamilies, and cohabiting adults. Blankenhorn's conclusion that married biological parents provide a better family form than married non-biological families is not supported by the evidence on which he relied, because the evidence does not and does not claim to compare biological to non-biological parents. Blankenhorn did not in his testimony consider any study comparing children raised by their married biological parents to children raised by their married adoptive parents. Blankenhorn did not testify about a study comparing children raised by their married biological parents to children raised by their married parents who conceived them using an egg or sperm donor. The studies Blankenhorn relied on compare various family structures and do not emphasize biology. The studies may well support a conclusion that parents' marital status may affect child's outcome. The studies do not, however, support a conclusion that the biological connection between the parent and his or her child is a significant variable for child outcomes. The court concludes there is simply too great an analytical gap between the data and the opinion proffered. Blankenhorn's reliance on biology is unsupported by the evidence, and the court therefore rejects his conclusion that a biological link between parents and children influences children's outcomes. Blankenhorn's third opinion is that recognizing same-sex marriage will lead to the deinstitutionalization of marriage. Blankenhorn described the deinstitutionalization as being a process through which previously stable patterns and rules forming an institution like marriage slowly erode or change. Blankenhorn identified several manifestations of deinstitutionalization out of wedlock childbearing, rising divorce rates, the rise of non-marital cohabitation, increasing use of assisted reproductive technologies, and marriage for same-sex couples. To the extent Blankenhorn believes that same-sex marriage is both a cause and a symptom of deinstitutionalization, his opinion is tautological. Moreover, no credible evidence supports Blankenhorn's conclusion that same-sex marriage could lead to the other manifestations of deinstitutionalization. Blankenhorn relied on sociologist Andrew Cherlin and socialist Norval Glenn to support his opinion that same-sex marriage may speed the deinstitutionalization of marriage. Neither of these sources supports Blankenhorn's conclusion that same-sex marriage will further deinstitutionalize marriage, as neither source claims same-sex marriage is a cause of divorce or single parenthood. Nevertheless, Blankenhorn testified that the further deinstitutionalization of marriage caused by the legalization of same-sex marriage would likely manifest itself in all of the consequences already discussed. Blankenhorn's book, The Future of Marriage, lists numerous consequences of permitting same-sex couples to marry, some of which are the manifestation of deinstitutionalization listed above. Blankenhorn explained that the list of consequences arose from a group thought experiment in which an idea was written down if someone suggested it. Blankenhorn's group thought experiment began with the untested assumption that gay marriage, like almost any major social change, would be likely to generate a diverse range of consequences. The group failed to consider that recognizing the marriage of same-sex couples might lead only to minimal, if any, social consequence. During the trial, Blankenhorn was presented with a study that posed an empirical question of whether permitting marriage or civil unions of same sex would lead to manifestations. Blankenhorn described as indicative of deinstitutionalization. After reviewing and analyzing available evidence, the study concludes that laws permitting same-sex marriage or civil unions have no adverse effect on marriage, divorce, or abortion rates, the percent of children born out of wedlock, or the percent of households with children under 18 headed by men. Blankenhorn had not seen the study before trial and thus was unfamiliar with its methods or conclusions. Nevertheless, Blankenhorn dismissed the study and its results, reasoning that its authors think that the conclusion is so self-evident that anybody who has an opposing point of view is not a rational person. Blankenhorn's concern that same-sex marriage poses a threat to the institution of marriage is further undermined by his testimony that same-sex marriage and opposite-sex marriage operate almost identically. During cross-examination, Blankenhorn was shown a report produced by his institute in 2000 explaining the 6 dimensions of marriage: 1, legal contract; 2, financial partnership; 3, sacred promise; 4, sexual union; 5, personal bond; 6, family-making bond. Blankenhorn agreed that same-sex marriages and opposite-sex marriages would be identical across these 6 dimensions. When referring to the 6th dimension, family-making bond, Blankenhorn agreed that same-sex couples could raise children. Blankenhorn gave absolutely no explanation why manifestations of the deinstitutionalization of marriage would be exacerbated and not, for example, ameliorated by the presence of marriage for same-sex couples. His opinion lacks reliability, as there is simply too great an analytical gap between the data and the opinion Blankenhorn preferred. Blankenhorn was unwilling to answer many questions directly on cross-examination and was defensive in his answers. Moreover, much of his testimony contradicted his opinions. Blankenhorn testified on cross-examinations that studies show children of adoptive parents do as well as or better than children of biological parents. Blankenhorn agreed that children raised by same-sex couples would benefit if their parents were permitted to marry. Blankenhorn also testified, he wrote and agrees with the statement, "I believe that today the principles of equal human dignity must apply to gay and lesbian persons." In that sense, insofar as we are a nation founded on this principle, we would be more American on the day we permitted same-sex marriage than we were the day before. Blankenhorn stated he opposes marriage for same-sex couples because it will weaken the institution of marriage, despite his recognition that at least 13 positive consequences would flow from state recognition of marriage for same-sex couples, including 1, by increasing the number of married couples who might be interested in adoption and foster care. Same-sex marriage might well lead to fewer children growing up in state institutions and more children growing up in loving, adoptive, and foster families. And 2, same-sex marriage would signify greater social acceptance. Same-sex marriage would signify greater social acceptance of homosexual love and the worth and the validity of same-sex intimate relationships. Blankenhorn's opinions are not supported by reliable evidence or methodology, and Blankenhorn failed to consider evidence contrary to his view in presenting his testimony. The court therefore finds the opinions of Blankenhorn to be unreliable and entitled to essentially no weight. Kenneth P. Miller. Proponents call Kenneth P. Miller, professor of government at Claremont McKenna College, as an expert in American and California politics. Plaintiffs conducted voir dire to examine whether Miller had sufficient expertise to testify authoritatively on the subject of political power for gays and lesbians. Plaintiffs objected to Miller's qualifications as an expert in the area of discrimination against gays and lesbians and gay and lesbian political power, but did not object to his qualification as an expert on initiatives. Miller received a PhD from the University of California at Berkeley in 2002 in political science and is a professor of government at Claremont McKenna College. Plaintiffs contend that Miller lacks sufficient expertise to offer an opinion on the relative political power of gay men and lesbians. Having considered Miller's background, expertise, and testimony, the court concludes, while Miller has significant experience in politics generally, he is not sufficiently familiar with gay and lesbian politics specifically to offer opinions on gay and lesbian political power. Miller testified that factors determining a group's political power include money, access to lawmakers, the size and cohesion of a group, the ability to attract allies and form coalitions, and the ability to persuade. Miller explained why, in his opinion, these factors favor a conclusion that gays and lesbians have political power. Miller described religious and political and corporate support for gay and lesbian rights. Miller pointed to a failed initiative in California relating to whether public school teachers should be fired for publicly supporting homosexuality and whether HIV-positive individuals should be quarantined or reported as examples of political successes for gays and lesbians. Miller testified that political powerlessness is the ability to attract the attention of lawmakers. Correction. Miller testified that the political powerlessness is the inability to attract the attention of lawmakers. Using that test, Miller concluded that gays and lesbians have political power both nationally and in California. Plaintiffs cross-examined Miller about his knowledge of the relevant scholarship and data underlying his opinion. Miller admitted that proponents' counsel provided him with most of the materials considered in his expert report. Miller stated he did not know at the time of his deposition the status of anti-discrimination provisions to protect gays and lesbians at the state or local level. Could only identify don't ask, don't tell, and the Federal Defense of Marriage Act as examples of official discrimination against gays and lesbians, and that he has read no or few books or articles by George Chauncey, Miriam Smith, Shane Phelan, Ellen Riggle, Barry Tadlock, William Eskridge, Mark Blasius, Urvashi Vade, Andrew Sullivan, or John D'Amelio. Miller admitted he had not investigated the scope of private employment discrimination against gays and lesbians and had no reason to dispute the data on discrimination presented in the Employment Non-Discrimination Act 2009 hearings. Miller did not know whether gay and lesbians had more or less political power than African Americans, either in California or nationally, because he had never researched the question. Plaintiffs questioned Miller on his earlier scholarship, criticizing the California initiative process because initiatives eschew compromise and foster polarization, undermine the authority and flexibility of representative government, and violate norms of openness, accountability, competence, and fairness. In 2001, Miller wrote that he was especially concerned that initiative, constitutional amendments, undermine representative democracy. Plaintiffs questioned Miller on the data showing 84% of those who attended church weekly voted yes on Proposition 8. 54% of those who attended church occasionally voted no on Proposition 8, and 83% of those who never attended church voted no on Proposition 8. Plaintiffs also asked about polling data showing 56% of those with a union member in the household voted yes on Proposition 8. Miller said he had no reason to doubt the accuracy of the polling data. Miller did not explain how the data in PX 2853 are consistent with his conclusion that many religious groups and labor unions are allies of gays and lesbians. Miller testified that he did not investigate the extent of anti-gay harassment in workplaces or in schools. Miller stated he had not investigated the ways in which anti-gay stereotypes may have influenced Proposition 8 voters. Miller agreed that a principle of political science holds that it is undesirable for a religious majority to impose its religious views on a minority. Miller explained on redirect that he had reviewed most of the materials listed in his expert report and that he had tried to review all of them. Miller testified he believes initiatives relating to marriage for same-sex couples arise as a check on the courts and do not therefore implicate a fear of the majority imposing its will on the minority. Miller explained that prohibiting same-sex couples from marriage wasn't necessarily invidious discrimination against gays and lesbians. The credibility of Miller's opinions relating to gay and lesbian political power is undermined by his admissions that he, 1, has not focused on gay and lesbian issues in his research or study, 2, has not read many of the sources that would be relevant to forming an opinion regarding the political power of gays and lesbians, 3, has no basis to compare the political power of gays and lesbians to the power of other groups, including African Americans and women, and 4, could not confirm that he personally identified the vast majority of the sources that he cited in his expert report. Furthermore, Miller undermined the credibility of his opinions by conceding that gays and lesbians currently face discrimination, and that current discrimination is relevant to the group's political power. Miller's credibility was further undermined because the opinions he offered at trial were inconsistent with the opinions he expressed before he was retained as an expert. Specifically, Miller previously wrote that gays and lesbians, like other minorities, are vulnerable and powerless in the initiative process. Contradicting his trial testimony that gays and lesbians are not politically vulnerable with respect to the initiative process, Miller admitted that at least some voters supported Proposition 8 based on an anti-gay sentiment. For the foregoing reasons, the court finds that Miller's opinions on gay and lesbian political power are entitled to little weight and only to the extent that they are amply supported by reliable evidence.